We are on now. Good afternoon, Mr. Raghuram. Nice to have you here with us.
Good afternoon, Renu.
Friends, we are doing these sessions, as you all know, we are doing all these sessions to get perspective and expert opinion from everyone in the industry. These sessions are meant to provide you some guideline as to how to deal with client situations. Today we have Mr. Raghuram with us. He is a leading lawyer, founder partner of Rank Associates, which was founded in 1982, dealing and specializing in real estate. And he writes regularly to Hindu, in Hindu Property Plus. It's a regular column that he writes, so nothing can be better. No one else can be a better person to answer our queries and address the situation of estate planning, especially in these COVID times. Sir, would you like to please go ahead and tell us how do we go about, we are all planners, we look at holistically with our clients, we want to take care of all of their issues. Real estate is one of the major assets and a lot of people goof upon that. So how should we go about it? If you can throw some light.
At the outset, Renu, I thank you and the members of ARIA for inviting me to talk about this.
My pleasure.
Asset holding and asset distribution are two aspects each person has to take care. And see, all along we have been living in a kind of a comfort zone where each one was going about doing their work. But because of this pandemic, there is a risk of who is there, who is not there. This planning becomes more important as well as immediate. We can talk about two parts. One is review of asset holding and restructuring if required. And the second part is asset distribution. Asset distribution is how the asset should be taken after the lifetime of a person. Coming to the first part, the assets are held in different forms. Either it is owned individually, or it is owned with the spouse, or it is held as joint family. And assets can be in a single location, multiple location. The location can be other parts of India or other parts of the world also these days. And some families don't have children. So these things have to be looked at while deciding the asset holding pattern and the nature of property as well. See, properties can be from residential properties to commercial properties, to shops and office spaces, to large tracts of agricultural lands, probably estates, some plots in some remote part of, say, any state. This is how a kind of bouquet of assets an individual can hold. For an example, there can be more, they can hold theaters also, they can hold malls also, many other forms of assets are there, but I'm talking on a very general note. So these are all the forms of assets one can hold. When we deal with clients, these days we see that the succession plan has to be integrated into asset holding. What the profile of children and what they do and what the children will do in the next 5 years or 10 years will also determine your decisions on your assets today. If you are going to have a large tract of land and if your children are abroad and they visit you every December for Christmas holidays with 2 bottles of scotch and 2 boxes of chocolates and go back in January, you leave that agricultural land or an estate or a loose plot somewhere in some remote corner to them. Will they later manage it, administer it, take care of it? Are all the questions which you have to answer today. This kind of lack of attention on properties which are away from city gives rise to encroachments, trespass, illegal transfers, and then it becomes more complicated because children who are not able to manage the properties when it is intact will never manage the litigation. The litigation will become very cumbersome. and it will go to the courts which has jurisdiction over the lands. Suppose you buy anywhere beyond Siriseri, the courts are Chengalpet or Kanchipuram courts. It will be very difficult to handle sitting in Chennai, and it will be more expensive, cumbersome. So today, I would recommend, if your son or daughter are not in a position to manage the properties which you are managing, this generation can manage many things, the next generation may not. You have to convert those properties into manageable assets. I would, I had suggested to many clients to dispose of certain properties which are outside and make them into either residential units or commercial rent yielding units in city, where either they are used or they can be kept under lock and key. There will be no question of encroachment or trespass.
Yeah, or they can move to financial assets as well, right? In need, if needed.
Yeah, that can be moved. Yeah. That I'm sure your association will be keen to do that.
Exactly.
I would suggest sell the properties and spend the money, but in the interest of your association, it can be shifted to financial assets.
Yes, definitely.
So this kind of review and restructuring is required so that the succession plan can be put into place. Then only, even if you are giving the property to your children, it will be better enjoyed or effectively used. So this is the first part of the discussion. If you have any questions on this, I'll be too happy to answer.
Actually, this was very useful because most of the times people, planners, people, they just focus on writing a will or, how do we transfer it to our children? And they miss out on the fact that how much the children can handle or not handle. And we have quite a few many clients right now who are going through a similar situation. So this is a very good point that you brought in, Mr. Raghuram. See, in this, when you're talking about asset restructuring, do we also look at who is holding, and can their names be added on? Suppose I am holding in a piece of land in Indore. Can I add on my son's name in it? And if that is the way, how does it happen? I mean, while I'm still living, or does it become a part of transferring it, or is it will come as a restructuring part in the whole exercise?
If you want to include the family members, like parents, children, spouse, or siblings, there is no big cost in doing it. The stamp duty is concessional. It's not going to cost much. It will be less than 1 lakh for each, irrespective of the value of property. It is not a percentage on the value. So any reorganization within the family is possible. At a very convenient cost. But if the assets are going to be jointly held by third parties, like partners in partnership, or a joint investment by a few investors, then the division will be slightly more expensive.
Okay. So this within the family thing is they just file in an application, go to the registrar office, or how complicated is it?
No, it's a settlement. You have to do a part. If you are owning it individually, and if you want to include your husband or child, then you can do a settlement of 50% or 30%, whatever percentage you want to share. Sometimes this is also based on the auditor's advice. If the auditor or a chartered accountant who advises you on tax planning advises you to hold the property in certain percentage, you can also do that.
Oh, great. Yeah, fantastic. I think this part was quite clear and very extremely useful. We can move on to the next part, I think, because all my questions that I'm asking you are more about the next part itself. So I think it's good if you can throw light more on now. What tools can be used to transfer this, and what will be the pluses and minuses with all these tools?
The normal general mode of transfer is, like I said, a settlement deed. Settlement is nothing other than, it's just a gift deed. Instead of calling it a gift deed, we call it a settlement deed. When you are giving the property to a third party, it is called a gift deed or a government. it's called a gift deed. If you're giving it amidst your family members, it's called a settlement deed. Otherwise, the concept is the same. You just transfer the property without consideration, without anything in return.
Mm-hmm.
So there are three broad ways of distributing the assets to the family members. One is settlement, like I said. Second is by a will. Third is by creating a trust.
Mm-hmm.
And like I said, the earlier scenario where it is jointly held by family members, one can do a partition and box it to each individual. You can separate the properties in the name of each individual for them to deal with it independently later. So that is a partition deed.
Okay.
And if two co-owners,
Yeah.
if husband and wife are owning the property, and you ask me about single person holding and dividing into two. Sometimes two persons hold the property and they want to consolidate into one name. That will be a release deed.
Okay.
If husband and wife have bought a property and you want any one of them to own the property absolutely, the other can release it to the other co-owner. So release deed is also one of the options.
Okay. So what we are looking at is, one is of course writing a will, which most of us are aware that it is done, and we'll talk about in details after this. Second is trust, rather it comes at the end. And the biggest thing that you spoke just now about are the deeds. So if you can put it like this, that you can have settlement deeds, as you can have release deed, you can have gift deed or settlement deed. And all these three things are kind of similar tools in terms of rules and regulations with slightly different names. Now, let's take up this settlement deed first, Mr. Raghuram, if you don't mind, because this is something which, if I'm not wrong, offers a very cost-effective way of transferring property rights to the next generation. So what are the drawbacks, and what would be and in what situation you would suggest a settlement deed? So both, plus what are the positives and what are the negatives for this?
Yes. No, we'll first narrow it down. Yeah. Let us first discuss about trust and kind of eliminate it.
Okay.
Because this trust is again a bit cumbersome. Yeah. If you're going to have the property in trust, you should have trustees and beneficiaries. And this trust should be a separate entity. It should have its own PAN, and it should have its own bank account, and it has its own compliance needs by filing the returns and all that. So unless the property is huge and the beneficiaries are not in a position to take care of it, and the owners have to appoint some competent persons to manage the assets on behalf of the children or the beneficiaries, the trust form is adopted. So it is very rare. So let us not bring it into this general discussion.
Sure.
So we can eliminate the trust part of it. Mm-hmm. And then it boils down to only two: settlement deed or will. Settlement deed is a gift, and will, which you write, which will take effect after the person's lifetime. So coming to settlement deed can be in two different forms. One is you settle the property today in the name of your son or daughter or wife and be done with it. One major condition in settlement is the document should take effect at present. The Latin term is in presenti. In presenti means the document has to take effect as on date of execution. Some people write a settlement saying, in the end they will put a paragraph saying, this settlement will take effect after my lifetime, which will make it as a will, though it is called a settlement deed and registered as a settlement deed. So settlement takes effect now. There are two variations in a settlement. Settling the property from A to B is a straightforward settlement deed. You can retain the life interest for A. So the father will say, I retain a life interest in the property. Subject to that, I'm settling the property to the son. In which event, the settlement of the absolute interest goes to the son on day of writing the settlement, but the father will have a very limited estate. If you ask me what is the limited estate, it is right of residence and right to enjoy the income from the property if there is any income. So these two are the life interest rights the owner can hold
Yeah.
and still settle the property to the son or daughter.
Okay.
Yeah.
So they cannot, they basically lose their right to have a buying or have a say in buying or selling or disposing of the property or transforming the property. Is that so?
They
Suppose
will
it's
have
a
a
piece
say.
of
They will
land,
have a say.
they'll have a say. Okay.
Suppose the father settles the property to the son, retaining the life interest.
Yeah.
If the son wants to sell the property in a year or two, both of them can jointly sell. But the son cannot sell alone, nor the father can sell alone.
Okay.
They become, till the lifetime of the father, they become joint owners of the property. But later, the father can also do a release of the life interest to the son. This life interest can also be released. Then the son will become the absolute owner.
Okay. Okay. So if I understand it correctly, this becomes a very flexible instrument in a way that you can pass it on to the son, but at the same time you're retaining your interest, so you still have a say in how it is disposed and everything.
Yes.
And later on, if you want to pass on absolute rights, you can also pass on the absolute rights to the son.
Correct. That can be done during the lifetime of the father.
Exactly.
Or if the father passes away, the son becomes the owner instantly.
Okay.
Without going to the registrar's office or without going to any court, no order, nothing. Just with the death certificate of the father given by the corporation, the son becomes the absolute owner in this case.
Okay. So for
there is no other expense, there is no other expense, no other process.
Okay. So when he goes out to sell that property, all he needs is the settlement deed and the death certificate.
That's all.
So in this case, is it possible for the father to go back and say, okay, now I don't want my son in the settlement deed? Can he take it back?
If he reserves the power of revocation, the document, he can revoke.
Okay.
But normally, if the power of revocation is reserved in the document, people still take both of them as joint owners, because subsequent, this revocation, right of revocation will throw up certain legal issues. When the father revokes, the son can contest it if they are not in good terms. Because the revocation itself will arise when there is a misunderstanding between both.
That's right.
So normally the power of revocation is not reserved. If the property has to come back to the father for any reason, they require the cooperation of the son. The son has to come and resettle the property.
Okay. Okay. That's interesting.
The power of revocation, exercising it has some complications.
Okay. Okay. So you mean to say, although there is a clause to, although we can insert a clause to revoke, for this power of revocation, but we actually practically cannot exercise it. Is that so?
No, practically that revocation will happen. Only if there's a misunderstanding, it will always be contested.
Exactly. Yeah. Okay. So
and it will throw it into a kind of a legal, it will throw it into litigation.
So it can be contested and then litigation issues come up, right?
Correct. Okay. But if both of them decide to put the property back in the ownership of the father, it can be done by another settlement.
Yeah. So then power of revocation is basically not needed in the settlement deed, I would say. Is that?
It is, though it is in law, it is available. It is not practically used, is what I'm trying to say.
Yeah. Okay. Okay. So typically, usually, how do you do it? You usually have that power of revocation inserted in the settlement deed, or you just don't? You usually don't do it. And
so we normally don't do, because when you put that power of revocation into the document, always the market treats the father and son as joint owners.
Okay.
Because if they deal with the son, and in the interim, the father revokes the settlement. See, the son's ownership is a little bit unstable.
Yes.
When the father will revoke, nobody knows. So their dealing with the son will not be with the same confidence. Yes. Which happens otherwise.
Exactly. Exactly. That's a technical issue we could have gotten out only from you, Mr. Raghuram. That's the advantage of having you around, teaching us and throwing light on all these issues. Thank you very much. Okay, so let's move on to the next one now, and have your views on those, on other tools.
The next possible tool is the will. The advantage of the will is that the person who writes the will has the ability to deal with the property, even though he has bequeathed it in the manner he has written in the will. It doesn't prevent the person from dealing with the property. So I would recommend, if anyone is uncertain about writing a settlement now, sometimes multiple properties, multiple children, which property to give to whom, if there are certain issues, and sometimes when there are unmarried sons or daughters, the parents will always want to wait till the new entrant coming into the family and the equations which may happen later. So they may not be willing to do the settlement today, making it more or less semi-permanent. For this, writing a will is always helpful. The advantage of writing a will are many. One is you can write any number of wills, and the last will prevail. Will doesn't have a stamp duty requirement, and registration is not compulsory. Because wills are written in several situations, so the law has not given any kind of parameters for execution or registration of a will. A will to be valid, it requires two witnesses who sign at the same time as the person who writes the will signs. Certain wills, one of the wills which was written in corner of a newspaper was also accepted as a valid will because the person wrote it in the hospital bed. So there's no question of any going to the registrar's office or going to a lawyer. It's a simple format. You can just say that I own these properties, and after my lifetime, these properties have to be taken by my son or daughter or wife or whomever. Under the will, tell me.
Yeah, no, like you said, it is a cost-effective way of doing it because there is no registration required. But later on, when we probate, how does the tax aspect and estate duties flow in? And
registration is not mandatory.
Yeah.
Registration is optional.
Okay.
You can still go and register the will, and it doesn't cost more than some 3,000 rupees. You have to take the witnesses also along, and all three have to go to the registrar's office and register. The probate part, I'll come to the probate part later. We'll first finish off the will part. So wills can be modified. You can write a supplementary will, which is called a codicil. You can write multiple codicils, or you can cancel the will and rewrite the will again. All these things are there. And you can also, like I told you already, you can also sell the property or do whatever you want with the property, even if the will is subsisting. And under the will, whether you give it to your children or family members or to a charity or to a third party or a friend or somebody, some outsider, the rules are the same. But in settlement, if it is not within the family, there is a stamp duty implication. It will be treated as a sale. Stamp duty will be 11% of the value of the property. If it is outside the family, then it becomes a gift deed. And there are also gift tax implications under the Income Tax Act. So giving it to a third party under a registered document is difficult, but giving it to a third party under a will is not difficult. So these are the
No, I said this is a very relevant fact, very useful.
When a will, a will requires probate if it is executed in the three cities, Bombay, Calcutta and Chennai, or if the property is situated in any of the three cities, then only it requires probate. Actually, Christian wills doesn't require probate, but the market needs a probate. If there is no probate, when somebody is dealing with the property, they will seek the no objection from the other siblings or legal heads. So normally, any will they get it probated, even if it is outside city. Otherwise, the lawyers have to take additional precautions as to get all the legal heads conform to the existence of the will, and also confirm that that is the last will, and also confirm that the will has taken effect. Because in the absence of probate, You don't know which is the last will of the person who is writing it. So everybody will be slightly skeptical if you act on one will and somebody produces another will which is subsequent to this. That will be a problem. So probating a will is a must. It was originally 3% of the value of property. Now it's also a fixed portfolio only. It's also not much. It's some 25,000 or 30,000 for a will, irrespective of any amount of properties it can cover. So that is again not very expensive, and will is also now a good form of distribution of assets.
Yeah, excellent. You make it sound so simple, Mr. Raghuram. You can do this or that, and there are so many different ways of passing on the rights to the property. I just want to have one clarity. The rates that we are talking, 3% of property and earlier, and now 25,000 and 30,000. Is it related only to Tamil Nadu, or will it be prevalent all over the country?
No, I can talk only about Tamil Nadu.
Exactly. Yeah, that is
if
true.
there are any state amendments in other states, I'm not aware of it.
Exactly. Okay.
I would request your members of ARIA to take this as a kind of a general discussion, and all of them have to consult their lawyer before acting upon their intentions. So please consult your lawyer. Don't take any decision based on this presentation.
Yeah, that is what I wanted clarity for all of us, that these rates might differ from state to state, right?
Yes.
Okay.
There will be minor variations in other states. Yes.
Yeah, exactly. Fantastic. What else would you like to add on for us so that we can help our clients better in disposing of or managing their real estate better?
They'll have to see any property, they have to keep supervising it, they'll have to keep visiting it, which if it is not within city, they'll have to pay their taxes, they'll have to get all the revenue records in place. Like there are some records like patta, extracts from the revenue registers, and at least once in 3 years, they'll have to get an encumbrance certificate to make sure that there are no kind of illegal transactions affecting their property. There could be forgery, somebody else can impersonate and sell your property. So if you let it linger for too long, then getting back to the status quo is difficult. So once in 2-3 years, you'll have to get an encumbrance certificate and check whether any registered transactions has happened on your property without your knowledge. These are the precautions one has to take, especially holding properties outside their area of residence.
Yeah, these are very useful things. I think, all of us advisors who are advising our clients on a holistic basis, these small things, if we are able to guide our clients through, we definitely will need a lawyer's help when it comes to trusts or doing a settlement deed. But for the routine maintenance, if we can help our clients manage their properties till they bequeath it in a right manner that they want to, will be an extreme, very good value add to our client's life, I suppose. Mr. Raghuram, can you give us more tips on such things with which we can enhance our services in terms of real estate and estate planning? Of course, we'll come to the lawyers when we need help, but how can we as financial advisor or investment advisors do for our clients in this particular area?
Yeah, when you deal with the property portfolio, please ensure that it is either jointly held, like you have the nomination facility in the bank for easy withdrawal of money from the accounts. So this will is another like a kind of a nomination. So whenever you deal with the property portfolio, please ensure that it is not held in a single name and left without any further instructions. So whatever is the next step, also you have to kind of have it planned and have it duly recorded. That kind of advice you can give it to your clients.
That's very useful. I also want to add on, ask one more thing rather. See, we do advise all of our clients to write a will. And like you said, wills don't have to be registered. So we also suggest them go ahead and write it on a piece of paper properly, keep it at a safe place where your family knows that that's the place in case something happens to you. They know they can reach out to that document, pull it out and act accordingly. Now, is that the will should be used only for real estate and immovable property, or should it include other things as well, like the financial assets and anything and everything? I mean, someone might consider their stamp collection as a property or something they would like to give away. So what all should will include?
They can cover all their assets. They can cover the furnitures, fixtures, jewelry, bank accounts, any unique piece of art.
Mm-hmm.
And the wills can be conditional. You can put a condition.
Mm-hmm.
We wrote a will where the lady, who was a spinster, had about 20 cats. And she gave the property to a person who will take care of those 20 cats and a tree planted in the front of the house by her father. So the condition was the tree has to be nurtured and the cats have to be nurtured. Only then the property will go to the beneficiary. So these kind of conditions can also be imposed.
When there are conditions like that, how is it ensured that those conditions are fulfilled? Or is it it's just by the giving a promise, or is there a court-appointed mechanism over there?
Either it is based on the trust imposed by the person who is writing it on the beneficiary, or you can appoint an executor to oversee this. So it is possible to appoint an executor in the will who will look at all these conditions and see whether they are properly complied with. Otherwise, the executor can apply to court and get the property out of the beneficiary.
Okay. Okay. So executor will have that right to do it, right?
Yes.
Oh, great. And are there any conditions for someone to be appointed as executor? And, what is the general guideline?
You should not be older than the person writing the will. That's only.
That's the only legal condition. Is that so?
He shouldn't go off before the person who writes the will goes off.
Okay. Okay. Yeah, that makes sense. A lot of sense, of course. Mm-hmm.
The witnesses and the executor should be in the age bracket of about 30 to 40.
Okay.
So that we have a reasonable presumption that they outlive the testator. Though it can't be applied in COVID times, that's a presumption which we have to take.
Mm-hmm. Yeah, so coming back to COVID, you rightly mentioned, Mr. Raghuram, how do we ensure during these times, what are the special measures that we should take because of COVID situation? And I mean, thankfully, in India, the mortality rate is pretty low and we don't see any youngsters losing their lives by the grace of God. But what are the precautions that people should take right now so that, I mean, if COVID happens, unfortunately, that part is there, but rest of it should not get messy.
The only precaution, the 3 steps we discussed today: review, reconstruction, and distribution.
Okay.
Has to be done now without waiting further.
Review, reconstruction, and redistribution, right?
Distribution.
Yeah.
Should happen now, in the sense it can't be done in a day. Yeah. Probably it can take about 3 months to 6 months or a year.
Yes.
But the steps, people have to start those steps without waiting for them to reach 65 or 70.
Exactly.
Where initially there was a kind of certainty to lifespan.
That's right.
Because of the uncertainty, it is better to write a will right now. Because the will can be changed, the flexibility is there. So as a first step, everyone should write a will when they hold the immovable property or other assets. As a first step, they like to write a will. And then can do the settlement or anything later, because just because you wrote a will, you are not precluded from doing the other things.
Yeah.
So then slowly they can do the other permanent measures. But initially they can do this will so that that confusion can be avoided.
So would you suggest that at this COVID time, at least the basic minimum that people can do is go ahead and write a will and keep it in a safe place, so that in case of some unpleasant event, at least the property and redistribution can be taken care of. So correct me if I'm wrong. My interpretation is that one step if people want to take right now, they can sit today evening itself and write a will and keep it in the locker and let their family know. Is that right?
I won't say that, not that simple.
Yeah.
They can fix an appointment with a lawyer, meet him over the week, write it in a proper form, and it's always preferable to have it registered.
Okay.
So that even if the will is lost, you can take a copy from the registrar's office. And a registered will, there is no presumption of compulsion, coercion, or undue influence.
Okay.
For a will to be valid, it should be written by the person on his own volition. So when it is contested, normally people contest it by saying that one son compelled him to write it in his name and all that. The moment you have it registered, when the person goes to the registrar's office and signs, the compulsion question will not arise. The own volition presumption will be valid. That is one.
Okay.
But subsequent modifications or changes can be registered or unregistered. Preferably, the person who has the physical ability to go to the registrar's office, I would request everybody to have the same register. That adds some authenticity and credibility to the will.
Okay. See,
and especially if the value of assets are high, registered will is better than the unregistered will, though in law both are equal. Okay. But I'm only talking about the market perspective.
Yeah. See, how does it work then? Suppose someone writes a will and it's registered, right? But then then they change the will, and they, by some accident or something, they're not able to register it. Then which one will work?
No, subsequent document will be valid. Last document will be valid, whether it is registered or unregistered.
Okay. Okay. But then whosoever gets it will have to, I mean, if the previous will, if someone, suppose I give it to one son of mine in one will, and then I change my mind later on and assign my second son on it. So the second will be legally valid, but there is always a possibility of litigation, right?
Yes.
So would you?
That is when people use the executor. That is why they appoint an executor and leave the copies with the executor.
Okay.
Instead of giving it to the beneficiaries directly.
Yes.
The executor can be an uncle or an aunt or a nephew or niece.
Exactly.
Or somebody respected and known to the family closely.
Exactly. That's a very useful information. But would you suggest that in case we have registered the first will, and most of the people should register, they should also, when they change the will, it's better that they make sure that it is registered, or
Yes.
just having a copy with the executor will be enough?
No. Except cases where the person is bedridden or incapacitated to go to the registrar's office, he can keep it unregistered. In all other cases, when you have the ability to go to the registrar's office, it's better to register.
Okay. Wonderful. That was very, very insightful, Mr. Raghuram. I think I can keep asking questions to you, and I'm sure you'll also keep answering. But I can't afford to take any more time from you. I've kept you away from your work.
No, but I don't want your members to log off without going to, if it's going to be too long.
That is very true. No, I'm sure we are going to be finding it so useful. We'll all go sit through the whole video. It was extremely useful, especially from the perspective of, as advisors, as holistic advisors, how can we guide our clients to do the right thing? They will, of course, need a lawyer's help, and then we would like them to come to you as well. I would like to share your number and email ID if they...
You can share me. Yeah, you can share my email ID. And if there are any specific notes, I'll be too happy to answer it.
Great.
That
would you like to just say out your number and email ID if it's okay with you? If it is all right with you, otherwise we can leave it at that.
Okay. Number is difficult because not all calls are taken.
Sure.
My email ID is raghuram@ranklaw.in. RAGHURAM @ranklaw, RANKLAW, one word, .in. And our firm's website is ranklaw.in.
Great. I'll anyways share this separately, but this was for the benefit of all the viewers who are watching the video and would like their queries to be answered. They can also reach out to Mr. Raghuram directly by writing to him on his email ID. Thank you very much, Mr. Raghuram, for sparing this time for us. The whole thing the insight is extremely useful. A lot of value that the advisors can add to their client's life based on these conversations, I'm sure. Thank you very much. Glad to.
Thanks, Renu. I wish you and all the members of ARIA good times ahead. Thank you very much.
Thank you very much. Namaskar.